Hey guys, how you doing? Jonathan Johnson right here in Lake Charles, Louisiana at the Johnson firm. I'm joined today by Erin Abrams. Both of us are family law attorneys that deal with custody cases all of the time, and there have been two really big announcements from the Louisiana legislature this session that we wanted to get with you and talk to you about because it can make a real big difference in two different types of cases. So we're going to go through the details on that. So Erin, why don't you introduce the first one to us, Act 605.
Sure. Act 605 has a pretty big, substantial language change. One of the biggest that we've seen in law changes in custody in the last decade at least, if not longer than that.
Yeah, I was going to say, I think this is probably the most significant change since they went back and redid all of the protective order language.
Correct.
And created all those presumptions.
I'd agree with that. So what 605 primarily does, it's an act to amend, to change where the starting evaluation of custody starts at. So in the past, it used to be a joint custody kind of basis in the beginning, and then parents would have to prove that a 50-50, otherwise known as shared custody schedule, was feasible and was in the child's best interest. And if they could do that, the law said that the court should give them 50-50 that shared custody. But now what we're seeing in Act 605, it reverses that entirely. Instead, what Act 605 does is it gives the court a starting presumption that it shall be 50-50. Let's talk about that for a moment, about shall versus should. That's a big change. That's one. But shall be 50-50 unless a party can show that it is not feasible or not in the child's best interest. So you can tell just by the language, it's a reversal of what we previously had.
Yeah, and what you were talking about the language specifically that we need to talk about is when the legislature uses the word shall. Should, may, those are discretionary terms that the court has broad discretion in how they apply it. So before, when it said that the court should award equal time sharing between the parents, that just made it discretionary.
Right.
It wasn't something that was a mandate by the legislature. Now, with this shall language, every attorney that has made it through law school, first year procedure and statute interpretation knows, hey, shall means something really important here. The court has to do this.
Yeah.
So it shifted that to say, okay, now we start with that. And then, as you said, proving that it's not feasible or that it's not in the best interest goes to the other side, the one that's opposed to 50-50 custody.
Correct.
So really just seismic shift in where the court's starting point is. And this isn't just for initial custody determinations. This isn't the first time that you and your spouse maybe were in court, you had just split up, or maybe you had a kid at a young age, you weren't with the other parent, and y'all went to court early on in this process and y'all stipulated. It's not just those.
Right.
It even affects modifications,
That's correct.
which if you've got a current custody plan right now and you know, someone advised you that, hey, the child's too young, or this judge kind of has a predisposition away from 50-50 custody, and so you stipulated to less than what you really thought was in the best interest of your kid and what you wanted. This is another bite at the apple.
Oh, it absolutely is. And while it's important to talk about what 605 does change, I think we also need to point out what 605 does not change. Okay, so 605 very clearly does not change any of the factors that create what the best interest of the child is. It also does not change how we determine the domiciliary parent or what factors would be considered for that. And it doesn't change child support. That was another big question. We had posted a newsletter recently about these updates on social media, and a lot of people were commenting with some questions about, well, how does this affect my child support?
Yeah, I looked through those comments. We were getting a lot of questions about a lot of things, and this is really just these two areas that we're going to talk about are very specific. They're very large, substantial changes to the law, but there's still a lot of the law that's left unchanged.
Correct.
And if you have questions in general, not just about these, but specifically how these impact your potential case, you need to sit down with an attorney.
Absolutely.
You need to ask those questions and get those answers. So it's interesting what you were talking about right there about what it doesn't change and what it does change. It also doesn't change who our judges are.
That's right.
Okay, so every judge has certain proclivities, just ways that they start a case, things that they generally believe. And it's important for your attorney to be familiar with the judges so that they can give you kind of the lay of the land of what this judge prefers and doesn't prefer. But if you're someone that's going to be opposing 50-50 custody, if you truly do not believe that is in the best interest of your kids for whatever reason, could have been the other parent's involvement, could be some abuse factors, it could be lots of different things. you now have to go in prepared to not only understand what the judge specifically is wanting to hear, what factors are most important to him, but you have to be prepared to establish that it's not in the best interest.
Absolutely.
When before you didn't have to do that. So the preparation between you and your attorney, your legal team, is going to be really, really important. Same thing if you're saying, hey man, I didn't get 50-50 custody, I really wanted it, so now I'm going to file a modification because this law helps me. Well, again, you're still going to be running into some of the same judges. And we don't know yet how they're going to handle this.
That's right.
We've reached out to some of them. We've talked to them about, hey, this seems like a huge shift to us. Most of them have said, yep, this is a big shift. But some have been a little reticent to say it's as big of a shift as we probably think it is. That, hey, they've always had to show me the best interest. And if they've, so I'm ultimately the determiner of best interest. Yes, the judge is. But the higher court, the Third Circuit, in our particular jurisdiction, they would be looking at what that record shows.
Right.
And if there was no evidence presented that that wasn't in the best interest and the language says shall start there,
Right.
well, that's going to be, ripe for, you to try this to the record and go get your final outcome from the Third Circuit.
Yeah, and exactly like you were saying, if you have questions about how this law could potentially change your case, either because you're going for a custody judgment for the first time or you're modifying a custody judgment that you already had in place, it's really important to speak with an attorney directly about your situation, but also be aware that there's going to be some certain parameters that us as attorneys don't quite yet know the full scope of how that's going to play out in court. It just kind of depends as these cases keep coming up. And so that was one of the changes that we saw, but like Jonathan mentioned at the beginning of this video, there's actually another change, both of these taking effect August 1st of this year, but the second one is Act 93. And Act 93 really applies primarily to when someone is changing a custody judgment. Do you want to kind of tell them briefly what that is?
Yeah, so the old law came down from a court decision. So Erin was talking about we don't know what's going to happen with this law change on the 50-50 custody situation, because we've got to kind of see how courts have interpreted it, how the Third Circuit, other circuit courts are interpreting it. That's where we get our case law from. Well, there was old case law, the Bergeron case. Bergeron v. Bergeron, divorce and custody issue go up. And we got this, what was called the heavy burden from the Bergeron case. All right? And in essence, what it said was that in the event that you actually took your case all the way to judgment, so you had a trial, not, I went to the hearing officer and the hearing officer made a recommendation and nobody appealed it. Or we were set for trial, but we all went to, we sat in a room, we talked about it, and we came to an agreement and we had a consent judgment. Or we went to mediation and we settled our case. None of those situations, this doesn't affect that at all. These were cases where you actually tried your case. Everyone put on their evidence, everybody was in court testifying, parties are sworn in, the whole deal.
What people think about when we say a day in court,
the trial, okay? And then at the end of it, attorneys made their arguments, and then the judge rendered a decision. That's what's called a considered decree. All right. In those situations, it was extremely difficult in a custody case. There were two prongs that you could meet to change it. Very difficult to change it. In essence, one prong was that, just call it actual harm, would come to the child if we didn't change the situation, which you can understand going from just best interest, a little bit better in this scenario than the other, versus substantial harm or deleterious, or the language that they used was very substantial. That the person that wanted to change this a lot of times we were meeting with them and say, hey, this is a considered decree.
Yeah.
You're nowhere close to what the burden is to change this. And they would leave a little without hope.
Yeah.
And let's say you had a 2-year-old and you tried the case. At 2, you had that heavy burden sit in. That was through that child's entire life, okay? Now, what this new act does is it changes all of that to give kind of a window. It says, hey, Bergeron is still going to apply. We're still going to have the heavy burden, but we're only going to have it in place for 5 years, okay? So if you, in the example that I gave, if you had a 2-year-old child and you guys went to trial and the judge rendered an opinion and you didn't like it, you didn't have any options before. Now, at the time that child reaches 5 years, now when you go back, all you have to show is a material change in circumstances, which again, the word material means some sort of significant change, and that it's in the best interest of the child. So it brings you back to the standard normal modification of custody language as opposed to that heavy burden that was set in Bergeron. So again, really, really big shift where, hey, you know, I met with an attorney 2 years after I went to court because I didn't like my custody plan, but he told me there was really nothing I could do about it because of this heavy burden. Well, that was 3 years ago. Now it's been 5 years. You're back in the game. And if you think that your custody plan's not what's right for your kid because times have changed, things have, the circumstances have changed.
A 2-year-old and a 7-year-old, that's very different.
Right. So there could be, you know, this isn't, you know, saying, hey, let's just open the floodgates of custody, but it was the legislature acknowledging that as time goes on, there can be some pretty significant changes in a child and a parent's relationship in life that might not rise to, you know, that heavy burden, but certainly warranted a modification of custody. So again, this is another really big change in the law that gives some parents that might have not had a way to get the custody plan they wanted, you know, back in it.
Absolutely, yeah. And so seeing both of these 605 and 93 go into effect again August 1st of this year, it's important now that everyone listening out there understand this information. Ask yourself, can this change my custody plan? Can this make my custody plan? How is this going to impact my case? And start asking those questions now so that when that law change takes effect, you can be taking advantage of it as soon as it becomes available.
And it's not just those that are, you know, hey, my custody case is over, do I want to go back in? If you have a custody case right now, okay, and I know this because I've gotten emails from clients. When we put this information out there, clients started emailing and text messaging me, hey, how does this apply? Had one, I went on a trip this weekend and I was getting off of a plane and my client texted me, hey, can you call me? And I said, hey, I'm kind of on a trip this weekend, would Monday be okay? And he says, yeah, sure, no problem. And I sent him a picture of our flyer, and I said, you saw this? He goes, well, why do you think I'm reaching out?
Yeah, that's why I'm calling.
I said, man, we had earmarked your case as one that this is really going to help. And so, you know, you need to talk to your attorney right now. You know, make sure they're aware of the law change. This is one that's going to make its rounds really quickly. Absolutely. I don't think there is anybody that's going to be doing custody law that's not going to be up to date on this information. But asking them, hey, how does this impact my case? You know, you might have had a consult 2 months ago where they were telling you very strongly that, hey, you're going to get joint custody with you domiciliary parent. You're going to have a custody plan where you got 65, 70% of the time with the child. That may have all changed.
Yeah, very well.
That information could be different now. So again, open dialogue with your attorney, ask the right questions. If you are looking to modify, you know, this very likely opens up some windows. Either one of these actions. One, if your case was a considered decree, gets you back in it. But number two, and, you know, if you didn't have that 50-50 custody plan that you wanted, you know, this really, really brings that back into play.
Absolutely, absolutely.
Yeah. So once again, Johnson, Erin Abrams from right here in Lake Charles at the Johnson Firm. Check us out on johnsonfirmla.com and give them our other website.
www.johnsonfamilylawyer.com as well.
Hey, we appreciate you watching that video. If you have other questions about other legal topics, check out our website, johnsonfirmla.com, or our YouTube page. We put out material all of the time in the areas of family law, personal injury, and criminal defense. We really appreciate you checking us out. Thanks so much.